Does the idea of trademark registration instantly conjure up images of astronomical costs? It's time to shift the narrative and ponder over the potential financial benefits that could be reaped from such an investment. Envision a future where you can cash in on your sweat-soaked trademark by selling it along with your business, or by licensing it to distributors and franchisees for a consistent flow of revenue. Suddenly, the initial expenses of registration seem like a mere speck in the sea, dwarfed by the possible returns. This isn't groundbreaking news, but it certainly necessitates a significant amount of planning, elbow grease, and a sprinkle of good luck. However, we are not here to rehash old information. Instead, we invite you to partake in our exclusive journey of turning a trademark registration into a small fortune. In this episode, we would first paint the background facts and information for you. Our story begins with an unexpected letter from a law firm. They sought a letter of consent from us on behalf of their client, whose trademark application had been rejected by the Hong Kong Trademarks Registry due to its similarity to our registered trademark. For those unfamiliar with the process, a letter of consent can be the golden ticket to turning a rejected application into a successful registration. The registry typically attaches heavy weight on such consent from the owner of the prior mark. In the world of trademarks in Hong Kong, we say the letter of consent is the king. You might then be wondering why we would consider assisting a potential competitor. Well, let's delve a little deeper into the fascinating realm of trademark conflicts. Contrary to what one might think, trademark conflicts don't necessarily equate to business conflicts. When applying for a trademark, you must select the classes you wish to cover. For instance, a restaurant might apply for Class 43 for their main business, but also Class 32 to protect their signature non-alcoholic beverage. Now, consider a healthcare company with a similar brand name. They apply for Class 5 for their healthcare products, but also want to extend protection to Class 32 for their healthcare beverages. Hence, the potential for a trademark conflict arises. However, obviously the restaurant and the healthcare company have fundamentally different businesses and target different customers. Since the pair of marks are not identical, it's unlikely that customers would confuse one for the other, even if both have trademarks in Class 32. To illustrate this, let's consider a different situation. Suppose the ABC mark is registered under Class 16 for stationery and another business also files for ABC mark under Class 28 for toys. Customers seeing the ABC mark on toys might think that the ABC brand, known for stationery, is expanding into the toy industry. This could lead to confusion, and is quite different from the previous scenario involving similar marks on the restaurant and the healthcare company. In such situations where identical marks could lead customers to believe that a business is expanding into a new domain, the potential for confusion is significantly higher. In our case, we recognized these fundamental distinctions and communicated them to our client, who agreed with our observations. Having established that there is no business discord between our client and the law firm's client, we can now focus on formulating strategies with our client to unearth seldom-seen potential monetization opportunities. In the next episode, we will go into some details of our strategy. Stay tuned for a story that you can't miss.